Hello, hello, hello. This is Attorney Mike Revlin coming to you from Chicago as usual. And it is a glorious day here in Chicago. So I made my thumbnail from a little picture I took on my walk. Here's the actual picture. I was just laughing at all the comments before we started in the chat. Here's the actual picture. It looks like, well, where are we here? I can't get it to come up. All right. Never mind. We'll figure it out. Let's get it going. We've got all sorts of good clips from all over the place.
The Circuit Court is now in session. The Honorable J. Joseph Rossi presiding. We are here. The people of the state of Michigan versus Kelly Fitzgerald, case number 21-0.
Okay, there was the clip. It's acting funny. Okay, there's the actual picture. It looks just like it. And then I put it into AI, said, give me a cartoon version. And then it throws hair on my chest. That's all. That's all I was trying to show you.
863-FH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on an allegation that Ms. Fitzgerald violated the court's order of probation. As an initial matter, Ms. Hamill, why don't you lead us off?
Yes, Your Honor. Officer Raisvels representing the Michigan Department of Corrections.
And Mr. Gears, would you place your appearance on the record?
Thank you, Your Honor. Brent Gears on behalf of Ms. Fitzgerald.
Very good. And Ms. Fitzgerald, would you please raise your right hand? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, I do.
Thank you. And Ms. Fitzgerald, you understand the maximum penalty I could impose on the underlying charge of operating while intoxicated. Third offense would be 5 years in the Michigan Women's Prison.
Yes.
All right. And you also know that if you disagree that you violated my order of probation, that you're entitled to a hearing. I would conduct
Otherwise known as Andrew's house.
that either by Zoom like we're doing today, or you'd be entitled to request it be in person in the courtroom. And during that hearing, I would appoint a lawyer to represent you, and your lawyer could cross-examine any agent of the Department of Corrections Probation Department that testified, as well as any other law enforcement officers, and could also use the subpoena power to bring in witnesses who would be able to testify and tell your side of the story. You understand you have a right to a hearing regarding this violation?
I do.
Very good. Mr. Gears, what's your sense as to where we're going to go next in this matter?
Your Honor, I believe Ms. Fitzgerald would like to resolve this matter by entering pleas. I explained to her what the allegations are. They appear to be old, and I think the more relevant part is that there's some period of time since this initially came up till now that she has some additional jail credit for. I believe she's willing to admit that and go forward, hopefully with the recommendation of this court here to be done. So.
All right. Is that correct, Ms. Fitzgerald?
Yes, I would like to be done. But last time I pled guilty because they told me the same thing, and that didn't happen. So I just want to be careful what I say.
No, I understand. And, you know, that's why I advise you that full 5 years in the Department of Corrections, because, well, let's resolve that jail credit issue. I have 314 days here. Is that accurate?
No,
I was going to say, I did talk to Ms. Fitzgerald about that. There appears to be at least 7 additional days from 2023 in this most recent arrest. Is that correct, Ms. Fitzgerald? You've been currently there for 7 days.
I get detained because I live in Newaygo County, so I get detained there and then wait for the ride.
And that was on this bench warrant.
Yes.
And you have no other time from April of 2023 until most recently.
Yes, I did 33 days last year.
On this offense?
Yes.
Okay.
Remember I told you how he told me I would get early release, and then that they didn't come get me for 33 days.
Okay.
And I asked them, and they said, yeah, no, they didn't. They came and got me the day that they were told to come get me.
Okay.
Okay. I mean, I guess what you know, and it's fair enough to have a discussion about the penalty here before we go forward. And I do note, the recommendation essentially would be if I do sentence you to 365 days in jail with the credit that you have, even the credit that I have here on the PSI of 314, with the way that our jail calculates jail credit and good time, I think that would essentially result in your release and probation being revoked as unsuccessful.
Your Honor,
Yeah.
per the probation violation report, which I did not write because I just got this case yesterday. But I have, including her current jail when she got transferred here today, I have 351.
Okay. Yeah. No, even more so than 350.
And that does include the time from last year. That was the 34 days.
That sounds
I
right.
believe that's what she's talking about.
Okay.
Well, and then that puts an exclamation point on it that the right, if I go with the recommendation, a full year in jail, then and give 351 credit, then you are done, that you'll be discharged from the jail because of the good time, and this will be revoked. And my alternative here is to is to impose a prison sentence, which I gotta say, Mr. Fitzgerald, it's been a horrible performance on probation. Essentially, you did nothing of what I ordered to be done. However, what else you didn't do is you didn't get picked up for another, drinking and driving offense, which is my main concern when I have a OUIL case on probation is I don't want anyone to go out and drive and hurt someone else. It whatever else you screwed up, you didn't screw that part of it up. And I do believe in a case like this, and it has been a substantial length of time since you picked up the offense in 2022. We're more than 3 years out. I used to do 5 years back when I sentenced you with probation. However, the maximum probation period got shortened down to 3 years. So now my folks that are OUIL thirds only get 3 years. So that's kind of working in your benefit as well here. And you would stick with that recommendation at this point, Ms. Hamel?
Yes, Your Honor.
Okay. All right. Well, that's what I would go with then. If I can enter into a Cobb's agreement at this point with Mr. Gears and Ms. Fitzgerald that I would sentence per the recommendation to a year in the county jail with 351 credit and be done. And I can understand your hesitancy, Ms. Fitzgerald, because I had my alternative sentence down here as 2 to 5 in the Michigan Women's Prison, which would give you credit for the year you're done, but it would give you another year over in the east side of the state, which I'm sure is not what you're trying to accomplish here. So with that, are you willing to enter a guilty plea, Ms. Fitzgerald?
May I say something first?
You may.
First of all, I picked this charge up in 2020 and in an attempt to save somebody's life. My story has never been heard.
Yeah, no,
I'm
I
not
do
going to get
recall
into
the
that.
underlying.
I'm not going to get
Yes.
into that. But I would like to say that I have not drank since then, and I have not drove.
Mr. Fitzgerald, can we do the plea first, and then I'll be able to address that with your help as part of allocution.
Driven straight to conjugation camp.
Everything you're about
You
to
do get a
say.
chance before I impose the sentence, Ms. Fitzgerald, to say your piece on this. So let's go through the requirements first, though. Ms. Fitzgerald, did anyone, other than the stuff that I just talked about on the record, my assurance that I'm going to sentence with the recommendation here, has anyone promised you anything in exchange for your guilty plea today?
No,
Anyone threatened you to get you to take a guilty plea today?
no.
So your decision to plead guilty is your own choice.
Well, wait. No, I'm being told that I'm going to be set free from probation if I plead a guilty plea.
Correct. And I did state that on the record, so that is part of the
Okay.
agreement. There's no secret agreement or behind the scenes agreement that you're relying on.
Because that
here.
has happened. So, okay.
Yeah.
Yes.
Oh, good Lord. All I was saying is I need a conjugation camp bound graphic or something I can pop up so I don't disrupt the flow. Of course, then I disrupted the flow and muted myself.
No, I understand, and you are correct to want to, as us judges and lawyers say, you're way better off if you get stuff in writing or on the record. That's the way to keep things on the up and up. So, what you're pleading guilty to today is essentially a failure to appear since some date back in 2023 to probation. Is that accurate, Ms. Fitzgerald?
Sure. Yes.
Okay, then I'll accept the guilty plea. I find it's voluntary and supported by an accurate factual basis. We can go directly to the sentencing portion. Mr. Gears, anything by way of elocution?
Just briefly, Your Honor, I did have a chance to meet with Ms. Fitzgerald this morning. She relays several concerns to me about the case being handled by prior attorneys and that. But more importantly, she believes that her story wasn't fully told in the PSI report. I think her reflection is that the PSI report was completed without her participation, not due to her own fault. And so I believe she is prepared to allocute and let the court know a little bit more, an explanation of what's gone on in this case since then. So with that, I'll turn it over to Ms. Fitzgerald.
All right, Ms. Fitzgerald, you may proceed.
Well, the case, I got picked up in 2020 trying to save my cousin's life because she was seizing. She lied to the cops and told them that I was high on meth trying to kill her. They got a warrant for my blood. There was not a single drug in my blood because I don't do drugs. And so right then and there, that already was her lying. But they didn't take that into consideration. And I have lost everything because of this charge. When I got to the hospital, my cousin didn't have her seatbelt on. She didn't break a single bone. They said they don't know how many times we rolled or how either one of us were still alive. I had my seatbelt on. I broke all my cervical spine. I crushed my sternum, my sacrum, and broke all the ribs on my left-hand side. I was a mess. Okay. My cousin pulled the steering wheel. She was mad because I wouldn't engage in an argument with her because she was in and out of seizing. It always resorts back to the same argument. Who got more Christmas presents when we were in 4th grade? Okay. At this time we were in our 40s. I'm now in my 50s.
I did not foresee that. That got me. That got me. Who got more Christmas presents? I did not see that coming. That's fantastic.
I have lost my career. I have lost 4 cars, a home, my children, and my mother because of this charge. When I was trying to take this to trial so I could tell you my story, but my mother was sick, and Matt Berry came to the jail and told me that he talked to the prosecutor and that the prosecutor said that if I would not take this to trial and that I would plead no contest, that I would kick out of jail with time served that day. So I agreed because my mother was sick and needed me. I went into the courtroom in front of you. I pled no contest. Matt Berry walked out the front door. I tried to talk to you. You said you need to ask your attorney. They took me back to jail. Nobody spoke to me for 2.5 months until my sentencing. My mother passed away 11 days before my sentencing. If I would have been given what I was told, my mother could very well be alive today. My 7-year-old little girl found her grandma dead on the floor. I have been through hell over this charge. My cousin has numerous times has tried to tell me that she's sorry, that she will do anything she can to help me. I have that in writing. Nobody's bothered to look at that. While I was in jail, 2 different times, the PSI scheduled 2.5-hour allotments for us to have our PSI. Instead of coming to the jail and doing it like all of the other people that were getting PSIs, mine was through video with this person. Okay. The first 2 minutes that I was on a video with her, I told her I want to exercise my constitutional right and have my attorney present. She got mad. She's like, you want me to, her exact words were, you mean you want me to reschedule this 2.5-hour appointment? And I said, no, yes, I would like to exercise my constitutional right. Then the screen went blank. Deputy Latre was the deputy on duty both times for both meetings that I had scheduled. there was technical difficulties. Nobody has bothered to check IC Solutions to see if the monitors were up that day. Nobody bothered to do that. They just assumed I was guilty. She wrote, Miss Norman wrote in my PSI that I made myself unavailable for an interview.
I mean, let's be honest. It's a safe assumption. It really is.
How do you make yourself unavailable when you're in jail? I didn't make myself unavailable. There was a technical difficulty that she didn't bother doing her job and trying to find out. I have been through hell. I have been through hell with this charge. I don't drink anymore. I don't even have the compulsion to drink. I don't see my cousin anymore. And I was driving back in 2023, I was trying to get a job down in Gun Lake at the hotel with my friend, and I got the job. And then she was like, "You have to drive, but you can't hang out. You can't start today. You have to go home." And I didn't want to drive. She's like, "You have to go. You have to drive my car home." And I didn't have anywhere to go, and it was raining, so I did drive, and I did get caught because her car was so bad. And but nothing else happened. I was just trying to drive home from a job interview. And I haven't even driven since that day. So I don't drink, I don't drive. And I honestly did not do what the police report said that I did. That is all a lie. And it all should have been dropped at probable cause. And I've been through hell because of it. So I just hope that you take that into consideration. I've lost my career. I've lost my kids. I've lost my mother. I've lost everything I've owned. I have been through hell. And all I want to do is go out and rebuild my life.
Well, you know, the thing that encourages me, and the one thing that encourages me about the whole story of this case, is what I said right at the outset, is that, you know, what concerns me when a person has a charge like this is that, you know, you're gonna drink and drive, you know, at some point in the future. And everything you've been through, a lot of people would turn to it and say, boy, I want to rebuild my life, but the way I'm going to do that is by going out and drinking again. How have you avoided not turning to drinking or drugs to deal with everything going on? Why not for you?
Honestly, I'm not even sure how to answer that question because I have done my share of AA. And honestly, when I never told my agent that I wouldn't do outpatient because I've been willfully on my own will going to Arbor Circle for 18 years. Okay. I grew up in an abusive home from my mother, and
Yeah, it's not working.
I've had trouble my whole life. Okay. So I have been willfully going to Arbor Circle for 18 years. I enjoy it. Arbor Circle is my happy place until the day I went there and they told you that I was only there 20 minutes. The whole thing was not true. And I've been dealing with them with Lara, trying to get that person in trouble for not documenting what was true. However, but the one thing I do have to say, I have taken a lot out of AA. If I go to AA now, it makes me want to drink. I don't go. But I have learned a lot from AA. And the two things that I learned,
Oh, that's fantastic. AA drives me to drink. That may be my new title.
well, the one thing that I learned is, well, people, places, things. And my cousin was definitely a people, place, and thing. Okay. And I didn't want her around me that day, but I got drawn into this situation. Okay. So that's one thing. The second thing is that if, you know, I've always had a higher power, but somehow, and I can't even explain it to you because it is kind of like magic. I have no compulsion. I don't have a compulsion to drink. I don't want to drink. Like thinking about drinking makes me sick. And I think it's because of the trauma that I've been through in this case.
Well, that's a very, definitely. I mean, oddly, the way the law enforcement system, of course, is supposed to work by imposing, like you say, even though the consequences, you know, at least to hear your side of the story were unfair and arbitrary, nonetheless, you recognize that, well, at the inception of it, it was because of this, at least perceived offense, and that's what got me here, and I don't want to do that again. Whatever it's working, Mr. Trill, my advice is, you know, the fact that you stayed out of trouble, you know, usually I get people in front of me because they got picked up again, sometimes for the same exact thing, and It's not the case with you. You know, you've been under the radar, as it were, but to do that means you need to stay out of criminal trouble, and you've successfully done that, which says to me you can do it in the future. You know, I don't think there's anything to be gained in your case, you know, by additional imprisonment or probation time. So I realize you don't have the case doesn't sit well with you in terms of how it was started or resolved, but I can say, you know, the reason I'm granting you, you know, termination of your probation at this time is because I don't deem that, you know, where you sit today, based on your conduct, that you're a threat to other people out in the community. And that's my main job, you know, up here, is to make sure the community's safe. I can't always explore all the nuances of every case. You know, there simply isn't time to do it. But, you know, I'm always interested in how people manage to make huge changes, and you know, you have made significant changes in your life. You know, I think that, you know, the lack of contact with the cousin who got you into trouble here, a very wise choice, and you've made a geographic change of location up to Newaygo County. And I guess my advice to you going forward is whatever you've been doing, you know, keep doing it because it's working. And absolutely, I can say for you, you know, the absolute worst thing that could happen in your life would be to pick up another OWI charge. You know, it's one of the most common charges that I see in court, and I'm sure that that would be true for the judge up in Newaygo as well. And you know, you just don't want another one because you know, the way the system works is then that judge is going to say, well, she's had her time in jail, or the only thing to do is to send her to prison. And I can tell you, with everything you've been through, the only thing that would be worse would be a year of confinement in the Michigan Women's Prison. You know, there you would find, you know, an even worse situation than anything you've dealt with over the last 3 years. So I guess my advice is, you know, keep doing what you've been doing to stay sober. The sentence of the court will be 365 days. With credit for 351 days served, and I will revoke probation at this time. So you're done with this case. You know, like I say, I understand it's been a horribly negative experience in your life, Miss Fitzgerald, but I do want you to take away the positives that, you know, whatever you've done on the flip side, it's kept you out of trouble and out of court and out of trouble with the law. Keep doing that, you know, and, you know, build on those positive things that you have learned, like you said you're able to do with the AA experience. You know, you did a good job of taking away the positives from you know, your time at AA meetings and things like that. So keep on building on those positives and stay out of trouble. And I wish you the best going forward. It is a final judgment today, so you can't appeal it, Ms. Fitzgerald. Your appeal would be by leave to the Michigan Court of Appeals. I will appoint a lawyer to represent you on appeal. And you know, I don't, you know, given all your negative experiences with the case, it may be something you want to pursue. They have green forms there at the jail. That's to ask me to appoint an appeals lawyer to review the case at no charge. If you do want to do that, you do need to fill out that green form and return it to me within the next 42 days, or I'd have to deny your request. And that's entirely your choice, Ms. Fitzgerald. If you want an attorney, they would review this, you know, lock, stock, and barrel. They may say, you know, because of the time elapsed, et cetera, and the deal resolved at the end, that there's nothing to appeal in a legal sense, but at least then you've got a legal opinion that says that going forward. So,
oh, sweet Jesus. What?
able to stay out of court and you know, enjoy the positive things that still are present in your life, Ms. Fitzgerald.
Thank you.
Thank you.
Thank you.
Does the jail have James Taylor there?
Sir,
Yeah,
I'm looking for James Taylor now.
he's gonna take you back to D3. And I see Miss Langston has turned on her video. I'll put both of you under oath. You want to raise your right hand? Do Do you both swear or affirm the testimony that you'll be providing will be truth, whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Yes, I.
Since thank you, Ms. Langston. I'll hear from Ms. Langston first, and then I'll turn to you, Mr. Mendoza.
Okay, so I originally called.
Hang on, just one second. Let me pull out the case file. So, Ms. Langston, I see that your claim is for $9,860 for engine failure negligent service. Is that correct?
Yes, Your Honor.
Okay, both parties are present in this case, and this is case number 39267. Go ahead, Ms. Langston now.
So, I originally contacted Edgar at Mecca Automotive to see if he could come out and do a diagnostic check on my car to see what was wrong with it and what needed to be repaired. He agreed that he would come to my house and, put the diagnostic check in the car to see what was wrong. The findings from that were that the oil pressure sensor.
I like how she would put engine failure on her little box. I don't know why. It seems excessive.
Was not working. So we agreed that he would come back and replace that part. Then once that part was completed, we determined that from there that the oil pump was not working. And we agreed that he would work on that to replace the oil pump. My car, originally the reason why I had called, because when the car started, the engine would immediately give a warning light that said it was the engine oil was hot. Not that the car was overheating, but the engine oil was hot and to immediately turn it off. So the car had to be towed to Mecca Automotive for him to work on it. He worked on replacing the oil pump, drain all the oil out, replace the new pump. And that from there was a couple other things that had to be done, like the oil had to be put in, some additional seals and stuff had to be replaced from taking it apart to repair. Once that was all done, this ended up being around June 10th. I was called and said the car was done and it was ready to go. The engine was on and it was running. When I got to Mecca Automotive, the engine was already on, the car was on, and Edgar said he needed to take a test drive. So he pulled out on the street, went hardly anywhere at all because he was back within 5 minutes, and you could hear that he just gone down the street, like maybe a block or two. He came back and he said, okay, everything seems good to go. You can go ahead and take the car home. It's done. I had already paid him in advance for the replacement oil, the oil pump, and all of that work that needed to be done prior to him calling me and saying the car was ready to be picked up. So I left that day, got in the car and I left, and I went approximately 500 feet down the road, and my car started making a very loud pinging and clacking noise. So I called back to my significant other, Aaron, who was there with Edgar, and said that the car was making noise. So they immediately told me to bring the car back, which I did. I turned around and I was back probably within less than 5 minutes. I was not able to go very fast, and the farther I was driving, the louder and louder the noise was getting. So when I pulled back to the automotive shop, they said that Edgar said it sounded like I blew a rod in my engine, and that he would have to look at it further from there. So
I mean, seriously, I can't even make fun of it. They don't even leave room for humor.
next week, he called me back and said that it appears that the engine oil was not pumping through the engine, which caused it to continue to get overheated. The oil got too hot and the bearings melted and blew through the engine, causing the engine to no longer be eligible to drive. So we called several mechanics.
To no longer be eligible to drive. It broke. It doesn't work anymore. Eligibility is not part of the conversation here.
To say, you know, other mechanics to find out what they thought was wrong with the car, why it would be making that noise. And they all agreed that what would make the engine start making that clicking and clacking noise was the oil was not going back through the engine like it regularly should.
Yeah.
We
That seems to be part of the problem.
there was a mechanic next door that had told us that he checked it with one of his tools that checks whether the oil is pumping through or not, and he said that the oil was not going through the engine, and the fact that the oil was not going through the engine is what caused the bearings to blow and the engine.
Yeah, this is fascinating. We get it. The engine doesn't work. It needs oil. When it doesn't get it for a period of time, then it breaks. That's how it works.
And have total engine failure. The mechanic next door also told us that he had told Edgar, don't let that car leave. It's not finished. It's not ready to go and not to be driven on the road. So I feel that one, the work that Edgar did say that he completed was to replace the oil pump. He did, but it was negligent work because the oil pump was still not sending oil through the engine. When I asked Edgar what he recommended or what he would be willing to do to fix it, he said nothing. There's nothing more that I can do, nor will I do on this car. And that I am not of any fault. It's all your fault for driving the car down the road, and the rods blowing and the bearings blowing through the engine was my fault for driving in the car. So at that point, there was obviously going to be no agreement. Edgar was not willing to help nor pay pay for anything that he'd already done. That was negligent work. And so that's why we filed the small claims. Now, when we were in the mediation room, Edgar mentioned that it was just people trying to rip him off for work done. Well, I had paid him in advance before I was even told the car was done and ready to go.
Langston, you have said that you paid him in advance a couple of times. What was that advance was for the repair, and how much was that?
That was for the replacement of the oil pump, the oil pressure extender, timing cord.
Why are you unnecessarily wasting the judicial time of this court?
Coverage. The total was 2,000. Sorry, the invoice is really hard to read. The total invoice was for $2,700. And I had paid him in advance. The reason why the claims is for higher than that is because now my engine is not usable. It needs to either be replaced or rebuilt. So I have an estimate for the cost to rebuild the engine, and that's where the amount of the claims came from.
Okay, and your claim is asking for $9,860, and your paid in advance was $2,700 for repairs. Is this $9,860 based on your value of the car? Is that what you're claiming?
No, it's based on the estimate I have for the rebuilding of the engine. The rebuilding of the engine sorry for my dogs. The rebuilding of the engine is $10,162. We owed my significant other, Aaron, owed Edgar for some other work done on another car, which we just subtracted from the estimate and figured that, we would claim that amount. It's a little less than engine
And then
rebuild.
you refer to a mechanic who told you, who is that mechanic that you're referring to? And do we have any evidence that you have provided in terms of his inspection? And
Submit whatever you.
I'm not talking to someone else other than you, Ms. Langston. The
Okay.
other person is not under oath.
Okay, it is, the mechanic is, name is Robert. He works at radioactive fabrication. And it is a building adjacent to Mecca Automotive where Edgar Mendoza works.
Thank you.
He
Do you have
specializes,
anything else to add?
he specializes in working on LS and LT engines, which is what one in my Camaro. And I feel that he was there and was also helping with the replacing of the pump, and you know, he has information that seems valid. I did call other mechanics as well as Chevrolet, and they all said the same thing, that the oil pump not going through the engine is what would have caused the bearings to be shot through the engine.
Is that it?
That's it, Your Honor.
Go ahead, Mr. Mendoza.
Hi, thank you, Your Honor. Just want to say, Mr. Kiska and his wife contact me around on the latest of June to check on their car after
June of this year?
this year, yeah.
Okay.
After I done another repairs on one of the other vehicles for Mr. Kiska, his spouse. And well, I checked the car over his location, and I know that what she stated, the car showing all the signs about oil pressure. There were like a Christmas tree with all the warning signs lighting up. They said somebody else has been working on the vehicle, and they mess up with the electronics and some stuff of the computer. Still, the car was able to crank it, but I hear there was something going on at the very beginning. So I just said, well, might need to take the car to the shop because over your place, there's nothing I can do about it. I'm not gonna drive it because sounds like there is problems. The warning sign is telling low oil pressure, so stop driving at the very beginning. So they towed the vehicle over my shop, and all down over there, still was no idea exactly what was going on. The first thing I did is drain the oil in front of Mr. Kiska. He was there, and the oil came out with metal shavings. That was the first sign. He saw the oil, and he said, no, it's looking good. I think he's expecting to see big chunks of metal or something like that. We are talking about metal shavings. It's just, you can tell the metal blended with the oil. And he said, no, it's looking good. Go ahead. Let's do the oil pump replacement. After we've been talking about the just descended unit, which I did over their place before they towed the vehicle. That didn't settle down the problem. That's the reason they agreed to take it down over my shop. So that was the first sign. Was my mistake to make Mr. Kiska sign any, like a waiver or something that telling me or excluding me about there was something wrong prior my repair. They also state the car has been driving for somebody else and got overheated, what she said, and they took it for a joyride or something. So at that point, the car was already with internal failures. We agreed to do the oil pump because that was the only thing telling, on the warning signs. So, okay, well, you want an oil pump replacement? That's what you got. That's what I did. I get a new pump for him, install it. Unfortunately, in order to do this, you have to do pretty much the whole surgery. I have to spend 5 hours to access to this thing. After I access to this thing, I got a new pump, installed it and everything, got primed with all the procedures, sealed the timing cover of the engine. I didn't open the whole engine, just the timing cover, and put everything back together, the water pump and the rest of the accessories. I crank it up, we cranked it up the car, he was there, and the car was running really rough. That's the reason they called the mechanic next door, who was specialized on these kind of vehicles. They did another repair on the intake manifold of the car because the car was running low RPMs since who knows. So the mechanic did this modification and make the car running properly again with the proper RPMs. And that was the part of my my neighbor next door. No? There's two shops, mine, regular shop, and the specialized racing shop next door. That's the only thing he did. He didn't put his hands more in. He checked the car and the car appears fine, but it wasn't because all the signs are still there. The warning signs, all the lights in there. So at the time we crank it up the car, immediately, as soon begins to run normal, begins to make clacking noises. Mr. Kiska get into the car and step on the gas pedal and rev it up the car, all full throttle. And he also took a video and sent it to his wife. I was laughing, blah, blah, blah. He's ready. And I said, well, he's ready. He has been paid. He paid me on payments. He never paid me on advance the 1,700. He just gave me 200, 400 till I complete the repair. So when I delivered the car to them, they were there, but the car has the problems still. Was cranking, was running, but still I hear the noises immediately. So as soon she get into the car and drove out of the shop, he rubbing tires and everything. He went out the road. Not even 5 minutes later, we received a phone call to his husband, and she stayed like, oh, the engine is making tapping noise, blah, blah, blah. And I told him, bring him back to see now what else. And they brought back, and she drove back to my shop.
I like the reenactment. It was very nice.
The car, of course, they've been doing more louder noises. So to get this this is the old pump. To get to this point, to get scratched and overheated, it's even blue with groups inside. You can tell has been friction and overheated. When I got to this point, I have to have it outside. I opened and I realized all this. But that was obvious to me from the very beginning when I drained the oil. There were problems prior I put my hands into the car. So they just asked me to do the oil pump replacement. That's what they got, oil pump replacement. I didn't rebuild the engine. I didn't open the rest of the engine. They have electrical issues. And that's how it turns. I tried to explain them to whoever works in the car before, they mess up with this thing. This doesn't get shot in 5 minutes. This takes some time. The car was, I run a Carfax, I have it here. And the last service, it happened on Stonewater Automotive. I have it here when the car was 528,000 miles. When they show up over my shop, the vehicle have 67,000 miles on it. So we are talking about almost 10,000 miles from the last service till they show up to my shop to get it repaired. All this time, the car has been parking over here, their house for the last 7 months, probably, or 6 months, something like that, because they were really, with a mold and stuff, spider webs and everything. But they knew already they have a problem. So they just been looking to find somebody like me, trying to help them out. And now this is where I am. I've been doing this for 25 years in Thurston County area. I think I've been here 2 times in all these several years. And unfortunately, they don't understand what happened with their vehicle. Somebody else messed up with this vehicle, and now here we are. That's the only things I can say. Well, I have the pump. I can prove you this pump belongs to this specific car. I have a bunch of pictures here.
It belongs to Ms. Langston's car?
Yes, that's the old pump from her.
Old pump.
The old pump. I put a brand new. It's still on the car, of course.
And that that mileage proof, did you provide to Ms. Langston
Mhm.
or Mr. Kiska before?
Yes.
Today?
Mhm.
I want to get on oath.
Excuse me,
I'll turn to you, Ms. Langston, in just a second. I'll give you the last
Okay.
word. Just 1 second.
okay, thank you.
Are you, anything else to add, Mr. Mendoza?
Well, I have some documents you can review and verify what I'm talking about. I have
And then
some,
you have not provided those documents to court files before today?
no.
Okay, have
unfortunately.
you given the copy to Ms. Langston or Mr. Liska before today?
No.
Okay. And what would they refer to before I look at them? What are they about?
I'm sorry?
So one of those that you were referring to was a service that they did when they had a mileage of certain number of 5,000 something, and then next one for after 10,000 miles.
Mhm.
What is the other exhibit or other evidence you're referring to?
Another evidence I refer, well, I have just, it says there were like some accidents and other services, but nothing like,
Can they both lose somehow?
you know,
And what is the make and model of this car?
it's a 2011 Chevy Camaro. It's a 14 years old car, which is what they are asking for that car. That's not the cost of that car. It doesn't cost 10,000, and it's not even a supercharged. It's not even, I mean, the luxury car. It's an SS normal engine. That's it.
It's not even a supercharged.
Nothing as luxury.
Thank you. So Ms. Langston, I see Mr. Kiska with you. I have not put him under oath. I'll give you the last word. If he wants to testify, I have to put him under oath.
Yes, please.
Yes, let's put him
You
under
want to
oath.
raise your right hand, sir?
Yes, sir.
Do you swear from the testimony that you'll be providing will be truth, whole truth, and nothing but the truth?
I do, sir.
Okay, go ahead. What do you have to add?
Okay, first off, I was there when we drained the oil. I ran my hands through it and there was no metal sharding of any sorts because I would have not gone forward with the process knowing if I had seen metal shards that the engine was already past recovery. Okay. I knew it was, and he showed me the original pump and he said he don't know why it quit working and opened it up and just shrugged his shoulders. And neighbor next door, Robert of Radioactive Fabrication, says he hooked his special tool up to it and said that the engine block was, or his thing was reading 0 on the oil pressure, and it was not pumping oil through the engine. It should not be let go. I had Esker twice before we let that car go. Is it safe to drive? And he said yes.
That was a special tool
You
right
know, I
there.
had him come out to the house, diagnosed it first. I had took a lot of preparations, and I paid him. Yes, it was. He said he'd take it payments, but I paid him all in full early before we even took the car. So, you know, I don't see how it was 200 here, 400 here, 500 there. Yes, but he was paid in full before we even got the car completed. And like I said, I took several preparations, making sure that engine was going to be fine before I shelled out $2,000 to have it repaired.
Oil pump replaced.
Yeah. You know what I mean?
Thank you. Ms. Langston, you have the last word. Go ahead.
I cannot remember what I was going to point out at this point. It's something, that the oil pump that Edgar is saying is from my car. I don't, how do I know that that is truly from my car? I did go back to Mecca Automotive after the car had, after this whole incident to try to come up with some kind of agreement. And we discussed what could be done later. And we kind of walked around the corner of the shop and he picked up an oil pump and said, well, this oil pump is not from your car. I do not know where yours is at the moment, but look in here. This is the area which I showed Aaron that there had been some metal shards in there. So he specifically told me the pump he was holding and showing me at that point was not from my car. However, if I had been told that there was metal in the engine oil once it was drained, or there was metal shavings all over the oil pump, I would have not continued with the work. The whole process of this was done with the intent knowing that I am looking to find out if my engine could be fixed or not. Obviously, it does, you know, you might have to do one thing and then another thing comes up or another thing comes up. So it is a special engine on the car. It is an LS99 manual transmission. It's the car itself, a 2011. If you look online, because I actually did think about just selling it, just not working on it anymore. That car, every single one of the 2011 manual transmission 6-speed is still selling currently for $22,000. The year before or the year after are selling for maybe 8 or 9.
11 was a special
So the
year.
2011 year is a very special year. It is still, people are still wanting that engine, that car. And for him to say that the cost of the engine replacement isn't even worth the 14-year-old car. Maybe the car's 14 years
Thank you, Ms.
old.
Blangston. I think we are going in a wrong direction. I can understand that certain cars can have different historical value. I'm not putting much weight on what Mr. Mendoza said regarding the age of your car and what his estimate might be about the value. Here, what
Okay.
I am prepared to rule on your matter, unless you have anything else to say within the next 1 minute or so.
No, sir.
No, sir.
Okay, so in this case, you have filed a notice and you're claiming $9,860. And then you testify that you paid him in advance to change that oil pump or certain number of services that you asked Mr. Mendoza to perform. And your testimony was that you paid him $2,700 in advance. I've heard your testimony. I have not seen any evidence in terms of any exhibits other than your testimony that you felt that because what Mr. Mendoza, how he performed on the car is not to your satisfaction. I have also heard testimony by Mr. Mendoza that he replaced the oil pump and then you paid him in certain payments. Now, what I have here is to make a finding that there is a claim of negligence, which requires that requires the proof by preponderance of the evidence that the other party failed to exercise reasonable care that a prudent person would do. He is a mechanic, so he's expected to perform the duties of a mechanic that an objectively person looking at that situation objectively will realize. So I have to show, first of all, Mr. Mendoza had a duty of care. Yes, he did. He had a duty of care to perform the service that a objectively reasonable person would expect. Did he breach that duty? He performed that duty, and I don't find that he breached that duty. He did what he was expected to and in what you asked and what an objectively reasonable person would expect. Now, that you're saying that your car subsequently has malfunctioned, I have to see evidence that that was caused by his malfunction or not or breach of his duty. If he had breached his duty, and then find what damages to afford. At this point, I am not convinced that you have met the burden by preponderance of the evidence to show, based on your testimony, that Mr. Mendoza has breached his duty of care. And
Yeah, she hasn't. I mean, it's hard because they were so hard to listen to. But yeah, at the end of the day, this is the right ruling.
And his breach of that duty caused the malfunction of the car. There might be more evidence, but I heard from you that you took it to a mechanic other than Mr. Mendoza, who agreed with you that there is some issue, but I have not seen any evidence to prove that. So therefore, I'm going to dismiss this small claims. We are completed with your case, Ms. Langston and Mr. Mendoza. I have dismissed this petition, this claim.
Thank you, Your
Just
Honor.
just so you know, Your Honor, I did upload documents to the case file. I don't know why you're saying there was nothing there. I did have the bill, the estimate, a statement. Those were all uploaded, but I understand. Thank you.
It might have been uploaded, but they weren't presented. They weren't. You didn't offer them into evidence, and I'm not being too technical, but you didn't bring it up and make reference to it. They're pretty loose here, but I mean, it's not even, you know, it's not even close by attorney standards. But even under the sort of pro se friendly small claims rules, you just didn't present it. You have the burden. It's over.
For your time.
I don't have them at hand at this moment. If you have filed within the last certain number of hours, they are not downloaded in the files. I did not consider that. Thank you. Okay, our last matter is number 9, Michelle Hunt versus Courtney Brown. That's it. Okay. All right. We are completed with the.
Well, we got a Michelle Hunt. Oh, you know, maybe your brother Mike showed up.
Of the people of the state of Michigan versus Jemiah Myers, 25-02663. Appearance, please.
Thank you, Your Honor. Cassidy Kachukas for the people.
Jeffrey Rossi on behalf of Jemiah, who's standing here to my right.
Okay, Ms. Myers has a probable cause conference today for a police officer assault and battery. You keep an eye on this one.
Yes.
And then there is a notice of a violation of bond conditions. It says the defendant was to make reports to a court agency as specified by this court. And the defendant was to participate in a substance abuse testing or monitoring, urinalysis testing 1 time per week, and report to pretrial services within 48 hours. It says on September 4th, 2025, the defendant was placed on GPS tether and released from Ingham County Jail. On September 11th, the reporting investigator called the defendant on the number that she provided to the court. She did not answer, and a voicemail was left requesting a callback. At the time of the writing of this report, which was this morning, the defendant has failed to enroll in pretrial service supervision. The defendant is not currently participating in substance abuse testing or monitoring under pretrial service supervision. How are we proceeding on the underlying matter?
Your Honor, the people have begun negotiations with the defense regarding this and a global with another case. However, we cannot formally place an offer on the record at this time because it will not comply with the CPRA, as I have not had an opportunity to consult with the victim. But I understand that the defense has only just been put on this matter, so it was my understanding that the defense may be requesting an adjournment of the PCC at this time.
Adjournment of the PCC. Is that what you want?
Yes, I've had this case for exactly 48 hours. First time I've had to even meet with my client. Ask for an adjournment. We are in discussion. On getting this case rectified.
You would like to treat next week as another PCC?
Yes, Your Honor.
Why hasn't your client complied with the bond conditions?
Your Honor, this is the very first time I'm hearing about this. I would have discussed this with her, but I knew nothing about any violation of bond. So I can either talk to her or maybe she can explain.
Why did you comply with the bond conditions?
So the paper stated where I was gonna go, I was get tested.
You're supposed to report to pretrial services within 48 hours.
I didn't have a phone. My phone was smashed during the incident. So I didn't have a phone. And when I know a place where I can go to get tested, and they wouldn't let me because they said I needed an order.
Why did you report to pretrial services? I'm not talking about your phone. Your phone being smashed has nothing to do with your requirement to report to pretrial services.
And I'm sorry, what was that?
Why did you not report to pretrial services? within 48 hours of your release. You were released from custody on September 4th. Today is the 12th. You were supposed to report within 48 hours.
Yeah, it was just a very misunderstanding. I would have reported,
What did you misunderstand?
What I was supposed to report. Because I had the tether on.
There was no misunderstanding. You were supposed to report within 48 hours. That's very clear.
No, I was very confused.
You might have been confused, but it had nothing to do with what the court indicated. You just gave me two reasons so far as to why you didn't do it. First, it was because your phone was smashed, which indicates you had a clear understanding that you were supposed to report, but you wanted to use the excuse that your phone was in disrepair as to why you didn't do it. When the court told you that that was not sufficient, now you're confused. You're not going to be confused about this. Remand her into custody. Your bond is revoked. I ordered you to test one time per week. I ordered you to report to pretrial services. You're not doing either.
Can I ask you a question? Where am I going?
To jail.
I know, but which?
Ingham County.
Okay. Can I have my grandma or my mom get my?
The wheels of justice are going to roll you right into the Wayne County Jail.
Because I owe her money. Can she get my property?
Are they here today?
No.
I don't know. You can have whoever come get your property. That's nothing to do with me. That you're going to be remanded right now. You don't have any control over your property. If they want to come up to the jail and the jail wants to release it, that's up to them.
Okay. Can you get my bag?
So she has another warrant.
Oh, sorry.
City of Lansing versus Jemiah Myers 3-02-03234. This is a collection show cause that you failed to appear for in July.
What was that?
You owe $390 on a City of Lansing case. That was before Judge Flores.
It was a payment plan.
You must not have been compliant.
No, actually, you told me to go to collections, I believe.
You must not have been compliant.
It was collections.
This is a 2023 case. Do you know what year we're in?
2025.
Correct. It says January 23rd, 2024. Defendant pled guilty to count 1. And they dismissed count 2. You were given fines. Total fine $325. They set it for a show cause April 10th, 2024 to see how and why you had not made payment. You failed to appear. You appeared in court later and spoke to the magistrate. She gave you an extension till May 28th, 2024 to make payment. And then you failed to do that. And then it looks like there was a bench warrant issued, but later that bench warrant was quashed on September 10th because you appeared via Zoom. And you said you would pay in full. You talked to Judge Ward then. You would pay in full by September 16th, 2024. September 19th have come and gone. No payment received. Here we are, May 19th, 2025. It was scheduled for an arraignment at 3 p.m. Your balance now is up to $390 because you're incurring late fees. May 27th, you failed to appear for the arraignment that was scheduled at 3 p.m. A warrant was issued. Then it looks like the warrant was quashed because you saw Judge Flores and he referred you to collections. You must have either gone to collections and made a payment plan and didn't comply, or failed to go to collections because there was a collections show cause scheduled for the 4th of September at 9 a.m. and you did not appear, which makes sense because you probably would have, no, you got released on the 4th. When are you paying this? You've been lingering on this for 2 years. When are you paying it?
Your Honor, I was like in the middle of jobs, and I was also in rehab.
Okay, where are you going to pay it though? Because you keep giving the court different dates that you're gonna make a payment and then you're not doing it. So this keeps cycling into the warrant status. When are you going to make a payment?
When I'm out of custody.
The bond on that one's $50 cash. You're gonna pay $50 to get out on that one, and then you need to report to collections on a payment plan. As it relates to this matter, we'll address your bond after your next court dates, since you can't seem to comply with the bond conditions.
Can I ask you a question?
You absolutely can.
I have a court date on Monday for my children. Am I gonna be able to go to that?
You have a court date at the circuit court on Monday? Okay, we can send word over there that you've been remanded so that they can writ you over.
I'm sorry, what was that?
We will send notice to the circuit court that you are in custody so that you can be written over. For your, okay?
Okay,
You're all set.
thank you.
Thank you, Your Honor.
Thank you. On the record, in the matters of the state of Michigan versus Jeffrey Smith, 25-01341 and 25-01214, appearances, please.
Thank you, Your Honor. Cassidy Kachuka, people. Good morning, Your Honor. We want you for Mr. Smith, the defendant of cause, Mr.
Okay, Mr. Smith has 2 sentencing scheduled for today. I have pre-sentence reports that were prepared on the 3rd of this month. Did you get a copy of those?
Yes, sir. Yes, sir.
Do we need to make corrections, updates, or deletions?
No, Your Honor.
Make allocution.
Your Honor, my client dispute the fact that he did not take responsibility for his actions. He said he's willing to take responsibility. He has taken responsibility. He believes that he's willing to follow all the conditions. He believes that he has already been punished by spending a lot of time in jail.
Sorry.
Our files indicated that he was released back in August 16. However, he is in jail. He was returned to jail. I believe for a misunderstanding about the condition of his bond on another case. He said that he's taking medication and he really did not remember what has happened the day when he was pulled over. However, he acknowledged that he had some things and that he should have not been drinking and driving. He also reported that he would not be doing that anymore. We also requested for sentencing to time served. And when he told the probation officer that regarding whether or not he's going to follow the conditions of probation, he did not impose a misunderstanding. He said he would abide by all the conditions that the court put if the court was to put him on probation. Thank you.
Did Mr. Smith want to share anything today?
Mr. Smith, you want to address the court?
Mr. Smith, can you hear us?
What was the question?
Do you have anything that you want to say to the court before I impose your sentence?
Okay, say it again.
That's what the question was. Did you want to say something?
Oh, yes, I apologize for the situation that occurred and,
Which one?
Which
one are we, which situation? Because there's so many. Just let me know which one.
The driving while impaired and the domestic.
Oh, okay. What about coming to court drunk? Are you apologizing for that one too? When you came to court drunk?
Yes, I apologize and it would never happen again.
What about the domestic violence? Are we apologizing for that one too?
Yes, I do.
Okay. Anything else we want to apologize for?
I'm sorry to have to go through this.
That was fun. I really enjoyed that.
for my behalf.
You said what?
Sorry that the court have to go through this on my behalf.
You don't gotta apologize. Yes, this is what they brought us here for. The prosecutors are
Okay.
here for the purpose. The defense counsels are here. I'm here. My staff is here. We're here every day for this purpose. So you don't have to apologize to us for the domestic violence. You should apologize if there was no contact order that didn't prevent you, to the victim and to the people that you're hauling into court to deal with this. You see this right here? You see
Yes.
this? Let me see how thick it is.
Yes.
Show criminal
Okay.
history. I've never seen a criminal history this thick in a sentencing file. You have, at least as of the 3rd, you were scheduled for sentencing on a domestic violence. You have a pending domestic violence. That is a pretrial on October 20th. You have arraignment, at least at the time of this, you were supposed to be arraigned on a new driving while license is suspended. You had a new pending open and toxin vehicle. And then you got a new registration plate violation that's pending. You come to court drunk, you don't come to court, you don't go to pretrial services or to probation when I tell you to report. You have not at all. And I've had to admonish you even for comments made to court staff in the hallways. You got a greater chance, sir, of going and winning the lottery than for me to put you on probation. That's number one. And to make the statement in court that you believe that you've already been punished enough because you're sitting in jail because you failed to follow the court orders and you have a current pending bond violation on this that we're not even going to address until October. Yeah, you didn't realize that. This case is still going to be pending. You got a bond violation. I set it for a hearing on the 20th because it picked up a new case as related to this. And so to say that you've already been punished enough to me is absolutely what the probation report is saying, that you have not taken responsibility for your actions. You'll be serving the full sentence on both files, 93 days in jail, okay?
Yes.
Do you have any questions for the court?
No, I do not.
Any additional matters for the record?
You know, while you were sentencing, do you take into consideration that he's still innocent until proven guilty on those pending charges?
That's why it was set for the 20th. I thought I said that.
I misunderstood.
Yeah, set for the 20th because he has a pending case on the other matter. He wasn't sentenced on the bond violation. It's set for hearing on October 20th. So we'll see him on October 20th on the bond violation.
I think she's had enough of this guy.
Any additional matters?
Nothing to be on.
And that's also the date that he has the pretrial for the domestic violence. That's why we set it that day, so that we can track the case. Any additional matters?
No.
You're all set, sir. We'll see you on October 20th.
Second.
On the record, in the matter of credit acceptance versus Ashley Brown, 22-013536 GC, appearance please.
Good afternoon, Judge. Francesca Servi for plaintiff P87205.
Okay, you're Ashley Brown?
Yes, I am.
Okay, today was the date that was scheduled for a hearing. This is for an objection to periodic garnishment. We received an objection from you, Ms. Brown. It states that you are objecting to garnishment because you was improperly notified of any, does that say hearing?
Yes. So I did some research and it appears that they reached out to a few of my other jobs like Kirchhoff, Champion, and I didn't get any notice of any of those. I feel like the only reason I got this one is because they sent it certified mail and I handle all the mail for my new job here at the Funeral Directors Association. But they garnished my taxes. I was not notified of any of that. When I've only found out that they garnished the taxes when I called the courthouse when I received this notice, because I was like, because they did, I saw the taxes were taken, but I didn't really look into it. But then I called the court once I received the garnishment, and they were like, oh, well, they garnished your taxes for this particular matter. But I was never given any notice of that.
Did you want to respond to her objections, counsel?
Yes, Judge, I will. Plaintiff had the writ of garnishment properly issued. It looks like that was back in July, so July 23rd, 2025. The writ was issued by this honorable court and then served on Garnishee Michigan Funeral Directors Associations, Inc. There's no court rule or statute or case law upon which plaintiff is aware that plaintiff is required to give defendant prior notice of filing its writ for garnishment, but the writ was otherwise properly issued by this court. And plaintiff would further note for the record that it sees that defendant was the person who signed the green card on the delivery of the
Yes.
writ of
Mhm.
garnishment, and plaintiff still has not received the garnishment disclosure pursuant to that, despite now having noticed that defendant is the person who signed the green card, as well as, I mean, her admitting in court that she got it. So a plaintiff would ask that you deny the objection to garnishment as it's invalid. There's not a requirement that plaintiff's aware of that plaintiff has to forewarn a defendant about a writ for garnishment that was properly issued.
But you are still required by Michigan rule to notify me to, I'm sorry.
Ma'am, that's not how this works. You see how I asked her if she wanted to respond?
I understand, I'm sorry.
Okay, that's why I'm here. I'm the referee here. I get to mediate this. So you don't talk back and forth, you talk to me. So a court rule for your objection to garnishment is very clear. And there's no court rule that allows or tells you that you can even file a garnishment. That you see where you request the objection and it gave you a section A, B, C, D, E, and F. Okay, and that's because those are actually the only ways in which the court rule allows you to object to a garnishment. You checked F, which allows you to say that the garnishment or the writ of garnishment was issued improperly or otherwise invalid, and then you wrote in that it was because it was improperly notified of any. You wasn't properly notified of any hearing. There's no hearing that comes with, you're opening your mouth to talk over me while I'm talking. There's no hearing that comes with a writ of garnishment. So I don't know what hearing you were looking for. There would have been no hearing. The other thing is you said that it was not issued or that writ issued after the initial hearing. Again, I don't know what you mean by initial hearing.
It's my turn to speak, I'm sorry.
That's correct. Yes.
So when I wrote this, it's because I literally was not notified of any other hearing even leading up. That's what I meant by hearing. So like, I understand that they issued the writ of garnishment, but I was never notified about a hearing for the judgment or any of these other garnishments. Like how am I supposed to respond to a garnishment?
Yeah, we know. If you would have been listening 30 seconds ago, you'd understand that there was no hearing. There is no hearing. It's not required. So your objection is, I wanted something to occur that never occurs in these cases. Okay, too bad.
If I don't have this, if I wasn't served.
Ma'am, you were served with the lawsuit in this matter, correct? And then you appeared before me back in December 1st, 2022. There was a joint pretrial statement that was completed. After that, you received your next court date. You were supposed to appear in this court on March 28th of 2023. That's over 2 years ago. You failed to appear. Default judgment entered against you.
I didn't notice is what I'm saying.
You failed to appear.
Have you ever had a failure to appear?
Possibly. You knew you were being sued. You were properly on notice that you were being sued, and the court sent the notice to appear for your next court date. That came from the court, and it did not get returned back to this court non-deliverable. If your address changed from the time that this court case began, it would be your responsibility to then go and notify the court, but it doesn't even appear that your address changed. So notice was sent for you to appear in court on March 28th, 2023. You did not appear. Outside of that, wait, I'm not done yet. Outside of that, ma'am, once you fail to appear, a default judgment entered against you, and the court then sent a notice of a default judgment to that same address.
Did not receive that.
So the court itself sent multiple notices to the address on file notifying you of A, to appear in court 2 years ago, B, that you failed to appear and a default was entered. Once that happened, that allowed you the opportunity, if you had responded to even the notice of default, you could have came back to the court and request to have the default set aside. But you never did that, and that's quite common. We get a lot of people that ignore that paperwork, and then we hear from them once it's time for their garnishments to take place.
Is it my turn to speak?
Yeah, we haven't heard anything we haven't received or heard anything from you on this file since
I didn't
October
receive
12th, 2022.
So in summary, you're not just stupid, you're predictable and boring.
I did not receive a notice for judgment. I did not receive any notice for judgment. I don't know if they was lost in translation because I was fighting the case. I definitely wouldn't have not appeared to that hearing.
Ma'am, you were advised by this court that you were doing a joint pretrial statement and that you would have some dates that would be kicked out from the clerk's office. You knew you were being sued.
I was advised of it, but that doesn't mean I was served.
What did you think happened after the next 3 years after you came to court? What did you think happened?
To be fair, like once I did receive the notice once I received the information about the garnishment, I honestly thought that they closed the case because they garnished my taxes. But I still was not notified of any of those things. I don't understand.
Oh, okay. I accept that. And you thought wrong.
Like I said, how am I supposed to respond? Because I would have responded to the garnishment way before now had I known about it.
Your tax garnishment is what you're talking about?
Yes, they garnished my taxes, but I did not know that.
Okay, so and that's not even what you're here for today. You're here for a different garnishment, correct?
I mean, it's all of them because like I said, that's not the first one that they did. They did multiple garnishments or at least attempts, but there was never any notification sent to me. How am I how am I supposed to respond to a garnishment if I don't have any notice of it? I only responded to this one because I literally received a notice.
I don't know what you mean. How are you supposed to respond to a garnishment?
Just like with this objection, like I'm objecting to it, I'm responding to it. I did not receive notice of those prior things. And I've done research on this company. This is not the first time they've done stuff like this.
Right, but I recognize you're objecting to the garnishment, but you're not providing the court with a objection that the court can consider. The court rule tells you what objections you can use. There are no such thing. There's no such thing as a hearing. There's no such thing as a hearing for a writ of garnishment. You don't get a hearing for
referring
that.
to the hearing, like I stated, that was the judgment hearing. I did not receive notice of that hearing. That's the hearing I was referring to.
Okay, that
Because if I had received notice of the judgment hearing, I would have appealed.
You cannot continue to talk over me.
There's no effing hearing. Get it through your thick skull. There is no hearing.
What I'm telling you is that same court rule tells you that you cannot use an objection to garnishment to attack the underlying judgment, which is what you're trying to do.
And I understand that, but what other premise can I go on if I don't have any notices? If I had gotten those notices, I could have objected earlier. That's my whole
What I'm
thing.
telling you cannot object to a garnishment so that you can attack the underlying judgment. You're saying the reason why you're objecting is because you did not get notice of the hearing in which you got a judgment for.
But it says that they have to serve you with these garnishments.
No, the court rule says you can't do that. It says that you can't do that.
So there are no rules saying that they have to serve you with the garnishment. Is that what you're saying?
It says the garnishment has to be properly issued, and it was.
But I wasn't served it, is what I'm saying. So how was it properly issued?
They don't have to serve you with the garnishment. They have to serve your employer.
Okay, so I don't understand then how somebody is supposed to respond if they don't have the information.
No, you were supposed to respond to the lawsuit, not the garnishment.
Ma'am, and I have already stated I did not even receive a notice for the second hearing.
But you can't use you can't object to the garnishment now
We
But
wouldn't
on that
be here though
basis,
if I,
the
we
court
wouldn't
rule is
be here though
very
if I had
clear.
received that
The
notice.
court rule is very clear. You cannot object to the
That doesn't make
garnishment to
any
now
sense.
attack the underlying judgment. Do you understand
I,
that part?
I understand that, but I'm saying if I
So why do
didn't
you
get
keep
notice about the
repeating that
initial
then?
hearing,
Why do
then
you keep repeating the
how?
same thing?
Because I'm trying to get you to understand that it doesn't make sense that to say that I can't attack the
I
garnishment if I was
I don't
never
have an
properly
issue with the
notified about the initial
understanding.
hearing. There
I
wouldn't
don't
be a
have the, I
garnishment if
don't,
I had
it's
been
not
notified.
me. I'm gonna terminate this hearing if you don't let me explain this the last time. I don't have the issue of the misunderstanding. I know the court rule very well. The court rule very clearly states you cannot file a motion to object to a garnishment because you want to now argue that you missed a court date or you didn't get notice that
I didn't
had
get
to do
notice of
with
it.
the
It's not as if an
judgment.
argument.
That's what the court rule says. So you are trying to say that you didn't get notice of the court date that you were supposed to appear for back in March of 2023. The court rule says you can't use an objection to garnishment to do that. I didn't make the court rule, man. That's just what the court rule says. Do you understand that?
Yes.
So
Judge, can
unfortunately,
plaintiff respond?
you have not provided the court with a reason under the law that I can grant your request to object to the garnishment. Yes, ma'am, you can respond.
Okay, just to correct the record, Your Honor, it was actually a summary disposition judgment that was entered in 2023, and it was also entered pursuant to the notice of 7-day rule for entry of the order. So defendant had notice to appear for that hearing through plaintiff's notice of a hearing. They had an opportunity to object to the entry of the summary disposition judgment. They didn't file a response to plaintiff's motion for summary disposition judgment. And as Your Honor had already stated, it's not a proper objection to writ for garnishment when you're attacking the validity of the underlying judgment under the court rules. So it's plaintiff would ask that you deny the objection is invalid and appreciate that you've done that.
I'm trying to explain so that the Ms. Brown can understand her concern, because I'm not saying that there's no other avenue for you to go and try to figure out what happened with your notice, or according to what they filed, you were served with a notice for your date to appear in court. And outside of that, you knew you were being sued. And so when you appeared in my court in 2022, there shouldn't be a next appearance 3 days later, or 3 years later, that is. You should have appeared at some point wondering what was going on with your case, because you knew you were being sued. And they had served you with discovery. They had served you with a summary judgment motion, which the court told you when you saw us would have a deadline date. And so we advised you of that when you were last here in 2022. When you didn't respond until this objection, and you can't now attack the judgment because the court rule says you can't do it this way. And so I have to deny your motion. Okay? Okay, so if you want to, I don't know what the balance is on the debt, and I know you said that you had some other garnishments that took place. You can try to meet with Ms. Servey and see if you all can work something out and maybe enter an installment payment agreement or another kind of settlement agreement that will prevent them from trying to garnish your wages. So if that's what you want to do. I could put you in the meeting room now for that purpose, to see if you can come up to another arrangement so that they won't be garnishing your wages.
Okay, let's do that.
Okay.
They're not going to offer
Our
anything.
next case this morning is people in the state of Michigan.
They haven't gotten paid. They have a garnishment. I can tell you that meeting's going to go. She's going to get in there and say, yeah, pound sand. We're garnishing you. The end.
Versus Stephan Jackson. This is going to be case number 25-3615 FH. Appearances.
Thank you very much, Your Honor. Attorney Robert Rich, Assistant Prosecutor from Sauk County.
Thank you, Your Honor. Taylor and Anna Cavento on behalf of Mr. Jackson, who will take his way out to council table.
All right, thank you, Mr. Jackson. Coaching the case. All right. Also before the court this morning is Miss Laura Odell. She is the agent with the Michigan Department of Corrections who is here today, and Mr. Blazek. All right. right, we're here today for sentencing on a case involving unlawful driving away of a motor vehicle and larceny in the value of $20,000 or more, and that's an attempt.
Can you guys hear this?
We're gonna take
It's a little
look
low for
here.
me.
All right, but take a look, please, at offense variable 12. Seems like that should be scored at 1 point, not 0 points. Wasn't there possession of a controlled substance at the time? Take a look here at CFJ 145. Oh, no, it was, yeah. Well, he did have an old prescription, allegedly. Did you find out if he had an old prescription?
Your Honor, the reason I didn't score that, thank you for a few minutes to catch up.
Okay.
The reason I didn't score that is because the controlled substance was found after the fact when the car was located.
Oh,
So I can't
all right. Nope, I
confirm
got it.
that.
I did not understand that from the way it's described here. All right, good. Then we don't need to add that. All right. Now, what about offense variable 19? I don't think that was scored. And when I look at CFJ 284 page, he made several extensive false statements to law enforcement, tried to say, no, it wasn't him, did all kinds of other explanations, lying to them when they're investigating the case. I think offense variable 19 needs to be scored. Let me take a look. Yeah. Yeah, I think court in offense variable 19 pursuant to MCL 777.49, the defendant should be scored 10 points because, as we can see here extensively, he lied a lot, especially in the second paragraph that begins, well, it's on CFJ 284 page 4, second from the bottom. And it just continues out, and it continues on even into the next page. And it was fact because of all of his lies and misdirections that he gave to law enforcement, that law enforcement spent a significant amount of time tracking down his other information to prove that it wasn't true. Mr. Ringstrom?
We do agree with the court that we do think that it should be scored at 10 points.
Ms. Fiorvento?
Your Honor, we would disagree with scoring that. We would object to the court scoring that variable up.
Why?
On the grounds that most of that information came from the police report, and I think we did initially attempt to do some sort of no contest, but the court rejected the no contest and said we did straight guilty.
Great.
So that information didn't come into the trial court record.
Sure. Mr. Ringstrom, what's your response to there? Is there anything you wish to bring to me to look at to make a finding by a preponderance of the evidence at sentencing, and considering that the rules of evidence do not apply pursuant to MRE 1101?
Yes, Your Honor, we would have a police report. It's kind of an extensive police report.
That's all right. Go ahead and bring it to me and I'll take it under consideration.
Under it, police report 24-2971-157.
All right, thank you.
And
Wouldn't have a sticker put on it by the clerk.
there are several supplements also, but I believe the information is in this original packet.
Court is now bringing in receiving People's Exhibit number 1, which is a Michigan, County Sheriff Incident Report 24-2971-157. And oh my gosh, it has 123 pages. One moment. On page 10, Mr. Jackson informed law enforcement that he did not take the vehicle, that he acquired it from another person at a gas station as he wanted to trade.
This is the judge in the South Sit divorce case, isn't he?
In and was trading his white colored Town and Country Pacifica ban for the Jeep, which we know already. I can take notice based upon the information accepted at the preliminary, I'm sorry, at the taking of the plea wasn't true. Then continuing over onto page 14 of this exhibit, there is a detailed description of telephone communication that the detective had with Mr. Jackson. Where he continued to double down on a story about trading it, his van, because he used it for driving shift. Then it continued on to page 15. He made up a fictitious story about this guy named Fred, whom he was, or from whom he was purchasing the vehicle or trading the vehicle. He had no knowledge that the vehicle had been stolen. Continues on to page 16. He even had a story as to why there was broken glass inside the vehicle, not knowing how it got there, which we know is not true based upon the plea. He denied having anything to do with taking the car and denied having been in the Cadillac area. That's on page 17. It continues on to page 18. About his whereabouts on the night of the, or day of the event on the 19th. I'm sorry, on page 19. He then sent to law enforcement emails that included video clips where he was trying to demonstrate where he was to prove he wasn't in Cadillac stealing the vehicle he admitted to. Then on page 20, beginning on page 20, continuing thereafter, it talks about how law enforcement went and got phone records from the defendant regarding the defendant's phone. And there was a search warrant for the historical connected video data that's referenced on page 22 and continuing after that. On page 23, it begins to describe the description of where the vehicle was and at what time. Is there a supplement, Mr. Ringstrom, that talks about? Well, no, I've already got enough. The court continues its finding of preponderance of the evidence. The court will score 10 points for OB 19. That brings the total offense variable points to 30 points. And thus far, we haven't gotten over to the council yet. Just thus far, that would increase the guideline range, I presume. We are on a class E, and that brings it from 20 to 30 points, which C brings us to 10 to 17. All right.
Bonnet life.
That would apply to both counts. Going to change the OB for that as well to a total of 30, level 3, 10 to 0 to 17. So, let me take another quick look here to see if I had any other issues. One thing I think we need to change here, and I don't know what the substance is, but it looks like on CFJ 145, page 1, under personal history for substance use history, or the missing one, right? If you look at CFJ 284, page 7, after this case, when he got, well, about this, around the same time, it looks like back in 2024, he was using cocaine.
I think that charge, Your Honor, was based on the narcos that were found in the vehicle when it was.
Okay, that's why I'm asking the question. I don't know what the answer is. All right, we'll leave that then this time. Let's take a look here at the other criminal history. I don't think I had anything else. All right. Mr. Ringstrom, any other amendments, corrections, or objections to make?
Although we don't have any other corrections, Your Honor, we do have a restitution number that is being sought at this point in time.
All right, and what is that at restitution?
$1,943.41 to Don's adopted car. $943.41 to Don's adopted car.
Okay. All right, thank you. Mr. Benton, any amendments, corrections, or objections to make to the contents of the PSI?
If I may place a few objections on the record, just for purposes of the record, Your Honor.
Sure.
First off, we would object to consideration of the police report. MCL 777.21 only allows for consideration of what already is in the police report. In addition, People v. Sauer says not every false statement to a police officer is grounds for a violation of OV 19. We
How
would
about when
argue
he
that.
lies? How about when he lies so many times that they have to go, and the only way they catch him is they have to go out and gather phones, collect all that data. Then he calls and sends them messages and screenshots of doing something else, being someplace else when it wasn't true. Is that more than just one lie?
Your Honor, I am making my arguments for purposes of the record. The police report was not in the record before it was solicited by the court here today. We would object to OV 14 as well. Under OV 14, currently my client is scored at 10 points under OV 14, asserting that he was a leader in a multiple offender situation. If I may direct the court to People v. I'm going to mispronounce this, Agni Essen, which is 311 Mish App 13. Just mere participation in a crime does not make someone a leader in that situation. I would also direct the court to People v. Dickerson, 321 Mish App 1. Again, mere participation in the crime is not grounds for preponderance of the evidence that someone was a leader in that offender situation. For that reason, Your Honor, we respectfully request that this be scored at 0.
Okay.
And
who was the leader?
That information is not in the record in any way. We have no evidence to indicate one way or another towards that.
Okay.
So there's not a preponderance of evidence.
What did he say last time as to why he stole the vehicle and took it to Muskegon? What was being done with the vehicle that he stole and took to Muskegon? Why did it happen?
I'm not sure exactly what the court is referencing, Your Honor.
No, I'm not referencing, I'm asking a question. Why did he steal the car? Why did he come here from Muskegon planning to steal a car? And there's other information in the reports that somebody helped drive him and he got I forget how he got transferred here. Go ahead. I mean, who else was there? Was there anyone?
Your Honor, based upon the information in the PSI and if the court, I'm still maintaining my objection. The police report cannot be
I got it.
considered.
Okay, great. Why
But
can't it
even
be
if we are
considered? Why can't it be considered?
MCL 7721.
What's it say?
MCL 7721.
Yeah.
Got it pulled up. I can read the statute. Except as otherwise provided in the section for an offense enumerated under part 2 of this chapter, determine the recommendation minimum sentence range as follows. I'm sorry, I was looking at OB 19. I do apologize.
It's okay.
Let me pull up the MCL for OB 14. I did have it up. I have several tabs open at this moment.
Now, there's another thing that, but we'll get to it. Keep going. I'm going to show you how you're probably missing the forest for the trees, but go ahead.
Your Honor, the issue here is not whether or not there were multiple participants. If the court wants to find a preponderance of the evidence, there are multiple participants. That is what the court is deciding. When it comes to OB 14, however, there is not any evidence to indicate who was or was not a leader if there were multiple participants. And that is what OB 14 is about. It is not about.
Before I go over that, do you have any other amendments, objections, or corrections to the content of the report?
Your Honor, we would object to the portions of the report which seem to draw again from that police report, which was not in the record itself.
Okay. We will have it set for a sentencing hearing. And at a sentencing hearing, which rules do not necessarily apply?
You're correct, Your Honor, that many of the rules of evidence do not apply at
Bingo.
sentencing.
We will set it for a hearing, which means if the prosecution, I'm not going to tell them what to do, but if they choose to offer a statement or they choose to call the officer in the back, they can do so. Now,
I mean, he's professional and he's mellow about it, but this judge is really annoyed right now. It's fairly subtle, but woo. Yeah, I mean, he puts up with a lot. That subset that was in here, he let him get away with a lot or whatever. For whatever reason, he is not liking this situation.
Here's another thing. I also could, what's the other thing I could do today? Even if we didn't amend the scoring.
Before sentencing as was originally planned.
Yep. And find reasonable grounds. But you have already told me, and here's where I told you, you got to see the forest for the tree. You already object to the contents of the report, which means we aren't going to do sentencing today. You've objected to it. The only way I can resolve that is by having a hearing. So we are going to have a hearing. We'll set it for a couple hours. It'll be in about 2 weeks. When I come back after my time off out of the office. And the prosecutor doesn't have to produce the entirety of the police report. He just needs to call the officer that works 30 feet away. But that's okay. There's nothing wrong with that. That's exactly the way the system is supposed to work. And I will ensure the due process. So, and by the way, it's still an intermediate sanction cell. But that's okay. If there are grounds to remove the scoring for 14 and 19, I absolutely, completely want to afford the defendant the due process he's entitled. And because you have objected to the contents of the entirety of the report, I cannot proceed and will not proceed with sentencing. We are adjourned. Bond continues. Ms. Ravento, you're shaking your head no at me.
I apologize, Your Honor. It was not an intentional gesture. If it was made, I'm
It's okay.
processing a lot in my head right now.
It's okay. It's all right. I understand. I choose to believe that, and I'm not going to take any offense to it.
All right. Is this woman pregnant? Not that it really matters, but like she's just very small. I'm just curious.
So, have a hearing. Thank you very much. Your bond continues. Yes, sir, Mr. Anything further? Thank you very much. We're adjourned.
All right, sir, state
All right,
your name and
Hector,
date of birth.
we're doing it.
Leon Marion George Jr., 12/02/2000. Your Honor, I know it looks bad. Okay, it's 12/02/2000? Yes, ma'am. Okay. Your Honor. So let me just tell you what we have here, okay? I know it looks bad, miss. You know what? I know my everything looks bad, ma'am. I know I got OR this morning. I know everything I have going on, ma'am, but I promise you, I've tried to make it to my court dates and everything. Well, sir, I got to tell you, I don't have a lot of discretion here. so let me just go through this. Okay, so you have a warrant for your arrest by the state of California. They want you back. They've already been contacted. They're gonna say they're gonna come get you. Now, did you read the laminated card? Yes, ma'am. Okay. So you have a choice to make at this time. You got one of two choices you have to make. One, you can choose to waive your right to an extradition hearing and be sent back to California within 30 days. That's option number one. Option number two, you can say, I'm not going to waive my rights, and I'm going to demand an extradition hearing and that a governor's warrant be signed by the governors of both states, California and Arizona, before they can send you back to California. So if you choose, you want to say, no, I just want to waive my rights and go over there, and you want to waive your right to that extradition hearing, you will be held in the jail here, no bond, for a period of up to 30 days to allow California to come and get you. That 30 days would start tomorrow as long as you do not have any criminal charges pending against you anywhere in Arizona. If you do have criminal charges pending against you in Arizona, the 30-day period would not start until those charges are resolved. Now, if you choose to have an extradition hearing, I'm going to set another hearing in our courthouse September 22nd at 1:30. I cannot appoint you an attorney to represent you because extradition matters are civil in nature, but you would have the right to hire a lawyer at your own expense if you choose. Now, you are entitled to bail in this case. It would be $50,000 cash. Yeah. You would not be entitled to, if you are unable to post your bail, you will be held in custody during that time or until another judge would modify your bail. A governor's warrant signed by the governors of both states requiring to extradite you can take up to 90 days. Do you know what you'd like to do? Option one or option two? Ma'am. If I say here, ma'am, my next court date wouldn't be till 10/23 for the charges that I do have pending out here. And I got OR this morning, ma'am. I know, that has nothing to do with this. Okay, so so I would sit until my next court date, which is 10/23, ma'am? Again, if you waive your right to an extradition hearing, you're gonna stay in custody for 30 days, and then California has to come get you and bring you over to California. Okay, but and then from there I would handle that, and I would have to come back for that court date next month for out here. I don't know anything else about what other court dates you have. I have a court date for October 23rd, ma'am. I know, but all I know is on this case, I don't want to make the wrong decision, ma'am. I know. So what you can do is say you're not going to waive your rights. That would take 90 days. It could be 90 days, but you can always change your mind because you're going to have another hearing in about 12 days. And if I say yes, they would come get me within 30 days, ma'am. It would be 30 days from that date. And so would I have to, so would they send me back out here, or would that case be? I really don't know. Or would I really don't know what would happen. I don't want to make the wrong decision. I know, if you don't know what you want to do, I can't accept a waiver, so I'm going to say you're not going to waive your right. And if I do go, that'd be 30 days, right? I was sitting here for 30 days until California comes and gets me. Yes, if they don't come get you in 30 days, you get released. They have 30 days to come get you. Sometimes it's quicker because they're next door. Sometimes they'll wait for the very last day. I can't tell you. But if they don't come get you, all I know is on the 31st day, you get released. Okay, and ma'am, when would the 30th day be, if you don't mind me asking, ma'am? Well, it would start tomorrow, which is gonna be the 11th. Okay. And let's see, 30 days has September. I've tried 19, it would be around October 11th or 12th, something like that. But sir, if you're unsure, waiving your rights to that hearing is a big thing. So I gotta make sure that you understand what you're doing. Now, you will see another judge in 12 days. And option 2 is the governor, that would be take up to 90 days, correct? Option number 2, right? Yeah, take up to 90 days, that's correct. But what I'm saying is you can change your mind and waive it on that next hearing if you sit and think about it.
I mean, I don't know the specifics, but this isn't a close call. You waive and you carry on. Otherwise, you're sitting there doing dead time that you're not getting credit for and not getting to your matters. Nothing's going to help. It's you. You got to go.
Is that an option, ma'am? Can I sit and think about it, Miss, till the next hearing? Okay, I'm not understanding what you're saying. Is that an option? Can I sit and think about it till the next hearing? I can't really understand what you're saying. Is that an option, ma'am? Can I sit and think about it until the next hearing, ma'am? Well, yeah, you can waive your rights when you see another judge on the 22nd. And if I waive my rights, it starts now, right now, correct? If you waive your rights today, that 30 days starts tomorrow. But now you're telling me that you have pending charges? No, out here, yes, ma'am. I just have I was OR for the case this morning, ma'am. Yeah, but if you have pending charges, those 30 days might not start until after that's done. That's what I'm saying, ma'am. My next court date is not till 10/23. That's what I'm trying to explain to you, ma'am. That's what I'm trying to explain to you, miss. That's what I'm trying to explain to you, ma'am. You know what, sir, I really don't feel comfortable taking a waiver from you because I don't think you know. Did you get a lawyer appointed for you at that next hearing? No, ma'am, he just OR'd me, ma'am. The judge just OR'd me. He just OR'd me, ma'am, and told me he promised. And when is that next court hearing? Next court date is until October 23rd, ma'am. When is that next court hearing? No, it's not till October 23rd, Miss. October 23rd. Yes, ma'am.
Oh.
The only thing I can say to you is that on the 22nd and 12 more days, you can tell the next judge that you've got another hearing on the 23rd. I don't feel comfortable because I know, Mrs. I know. I don't think you should waive your right. You see what's going on, bro? Because I don't think you legally understand this.
Stunning and brave. It's always beautiful to see a man break down. So in touch with his feelings. Y'all know how much I love it.
So I'm going to say you're not going to waive your rights. I'm going to set your bond. It's going to be a secured or a cash bond of $50,000. Can you please lower it, ma'am? Could you please lower it? It's already $25,000 out there, miss. It's already $25,000, ma'am. And then when you go to the next judge, you can ask the judge to reduce it. Please, ma'am. No, sir, this is my only two options that I have. It's not up to me. California has requested that they're going to come pick you up on these charges. Okay, yes, ma'am. And so I know you said you don't feel comfortable Because I really don't. So you're gonna see another judge in 12 days. Okay? All right, you're gonna get your paperwork. Court staff will bring you your paperwork, okay? Yes.
Whatever. The sync is off for some reason. It doesn't really matter. It doesn't really matter that we get the general impression of his physical affect here, and then the crying and the whining is top notch. It really is.
Ma'am. All right. Can I ask you a question? So if I do have pending charges, I would sit all the way until that's finished, right? At my next court date, which is 10/23, correct? Right?
The 30, even if you waive, the 30 days would not start until.
That case is over with.
Correct.
And you don't feel comfortable doing that, correct?
Well, no, I don't feel comfortable with, because I don't think you really understand enough about this to waive a very important rights. So make the state get the warrants. That's gonna start right now.
Okay.
That 90 days is gonna start right now. Okay? And you could be waiting 90 days for that other case to be disposed of, because if you don't have a hearing till October, it could take 30 days. If you get acquitted, that would be the end of it. But if you have a sentencing, that could take another 30 days. So you're better to get.
I mean, I don't really care, and it's minor, but I think we've almost crossed a line of, like it makes sense that she says, I don't want to take a waiver, but now she really doesn't want to take a waiver, and I think we've crossed over into like giving advice, and not only giving advice, which is inappropriate in itself. I mean, we're not there, but it's on the verge of that. But she's trying to push him in a direction, and on top of it being inappropriate, it's wrong. It's very minor. I don't care. This guy's sitting in jail anyway. You slice it. None of this matters that much.
This 90 days started right now.
90 days. So I have to wait.
Okay.
I have to wait here 90 days now.
Well, I don't know if it'll be 90 days, sir. I really don't.
But
you can talk with the next judge in 12 days.
But they are coming to get me, though. California is coming to get me.
They'll be notified that you are now demanding that both governors sign a warrant. Okay?
And that's for that warrant is for California.
That's the part that they only have 90 days to get.
So I'll be held for 90 days.
Unless you post the bond. And the next judge, you can ask the next judge to reduce it if you want.
Cool with that.
All right, I need to move on, but you're gonna see another judge in 12 days, okay?
Okay, ma'am. So I'm gonna sit for 90 days, ma'am?
What I said is, the other case could get dropped. You could get another judge that lowers this and you could bond out. There's so many variables. I can't tell you what's going to happen right now.
And if I do waive my right,
Emasculated and stupid is no way to go through life, son.
and I start the 30 days today or tomorrow.
You still got to wait for that other case to see what they're going to do on it. Okay.
Okay.
I'll try this one more time.
Well, there you go. Well, we end on a high note. Well, by let's talk with Mike standards, which is a low note. Lots of good stuff there. Was that Elmore or something? He was burning with rage, but is so mellow in the presentation of it, it's hard to see. But he was, I mean, that attorney was taking a wild position. And then this guy I mean, I think the judge is okay. I think it's fine, but she really got into all this other stuff. It's just like, look, here's what you say. I need to apprise you of your rights. And if you are wanting to waive, you have to be clear about it. And you are not. So we're not waiving. That's not the end of the world, but I think she went a little past that, like, oh, this is a very important right. Of course it is, but it seemed like advocacy. And ultimately, I think advocacy, if you were trying to help the guy in the wrong way, you're screwed. It's you. You are going to California eventually. Today, since you can't make up your mind and do anything, you're just sitting here for another 12 days at least. That's not going to help you in any way. You're just buying another 12 days minimum. That you're incarcerated. Now, I whatever, it's a high bail amount. The guy's probably the guy's probably going to be convicted on something serious and spend a lot of time in jail. So really, this is a tempest in a teapot. None of it matters. But just off the top of my head, I'm looking at this thinking, waive that damn thing, get to California and face your issues. I can't imagine how that's not the best thing for him. It's possible. I might be missing something. Criminal attorneys, tell me if I'm just missing the boat on this here somewhere. But I can't see where contesting this extradition is helpful to him in any way, shape, or form. That doesn't mean it isn't. I'm just saying I cannot mentally come up with any reason where that's helpful to him. And that's where we are. All right, lots of good stuff. Fun times. Everybody go behave yourselves. As usual, I will not be bailing anyone out. I've never bailed anyone out my entire career. Never once. And I don't plan on starting now. Thanks for coming out.